how does that factor in? Well, and who started it? Who was following who? Who was chasing who? Who had the right if they were being chased? Does the defendant have the right to self-defense? I'm sorry, does the victim? When he's being chased by this person? You'll hear the facts in this case, and you'll hear in terms of whether the defendant was chasing him or not. You know, it was dark out there. There's no dispute about that. It was raining. No dispute about that. And that's what these photographs show. It shows the distance from the sidewalk or dog walk to where the body was. Shows where several items were. And you've got the diagrams and you've got the photographs. One thing I would submit that these photographs show is the absence of blood on that sidewalk. The other big thing is, if the defendant was really having his head bashed in, as he claims to the police, and he has some injuries to the back of his head, and we'll talk about that, but I think they were, what, centimeters or less? Why isn't his jacket all torn up? Or at least scratched up? If he was being picked up over and over, why is his jacket all right, the back of his jacket? You think about that? Or is he exaggerating what happened? Flashlight, that was with the key ring, and that's the one that was still on. Stage Exhibit 10 showed another angle in terms of the evidence out there. In terms of there apparently was some slope, and we'll talk about the significance of that, because based on what the defendant told the police. And again, this is showing Stage Exhibit 15, so the body was covered up. That's the other flashlight that the defendant had, and I think he told the police that it stopped working or something. If you want to, check again his statements to the police. Was he carrying it in one hand? Why was he carrying it in one hand? Okay, I guess he took it out there to see, tracked down Trayvon Martin, and then it just stopped working, so he didn't put it in his pocket. I guess he was carrying it in his hand. That's the victim's phone. There's no dispute that he was talking on the phone. And this is how, when they attempted to save his life, he was turned over. I'll show you this photograph, not to show you just that, but I show you that because I want you to focus on this. He was speaking on the phone, and he had ear plugs or whatever you call them. Stage Exhibit 22 is a close-up of where the gunshot was. And also this photograph button. One thing I'd suggest to you that might be important to note on that is there was a big deal made about the jacket. Sure, it is kind of hanging. It's a little big on him, but also that might affect the angle of how much is sticking out of the sweatshirt. You decide. Stage Exhibit 23, why is that important? Do you see any blood on his hands? On the victim's hands? Stage Exhibit 24, do you see any blood on his hands? I mean, is there any dispute that the defendant's mouth, nose, had some blood on it? How come there isn't any blood on the victim's hands? Because the argument was made or suggested to you in terms of the cross-examination of the medical examiner and all that. Oh, you had to wash his hands, so that was inaccurate. You know, you all didn't know what you were doing there. Well, right there at the scene, where was the blood? The other interesting thing is that I will submit to you, just based on the evidence, I don't know what you call this, I don't know if it's a drawstring or what. Why is one of them a lot longer than the other one? Was the defendant maybe pulling on that as the victim was trying to back out? It's ironic that you see how one is pulled all the way down? And which side is it on? State Exhibit 29 just shows some of the other exhibits out there. State Exhibit 33, I put this in here because I thought, and we talked about it, I believe it came out during the testimony, that there's a street address right there. That's where the defendant claimed he didn't know, A, the street name, or he couldn't find an address. Even though he's lived out there 4 years, he takes his dog out there, or dogs out there to walk, but he doesn't know that there's street addresses, because this isn't just like some fancy or just regular neighborhood that all the houses are different. These are kind of cookie cutter. They're all the same. But he didn't know that there was addresses out there, so that's why he had to walk that long distance to find the address or find a street for the police to aid him. State Exhibit 36, those are just some daytime photographs, kind of showing you the area in terms of what happened out there. State Exhibit 76, there's been a big issue about that photograph. It shows how the defendant was bleeding. I believe Mr. Manalo took that photograph. Why is the blood still on there, and why would the blood not be on the victim's hands? It's interesting, too, the direction of the blood, and we'll talk a little bit about that in terms of what happened. State Exhibit 77, this is again Mr. Manalo before the police got out there. Where are the victim's hands? But under his body? What did the defendant claim to you? He used police jargon in terms of suspect and, well, the police, of course, they always spread out the arms, the hands, to make sure there's no weapon there. Because he's trying to tell the police that what happens is he was scared, and he at one point said, oh, I thought he had something in his hand, so I was checking for that weapon. That's what I was doing. Well, it's inconsistent with the physical evidence out there. Now, defense may argue, hold on, didn't Dr. DeMaio say that you could take out a person's heart and then they could live for 15 seconds and that the person could kind of walk or do all this other stuff? Okay, so you take out the heart, then the defendant kind of moves him and spreads out his hands, and so he's taking even more blood pumping out, and he's able, and then the victim just kind of happens to just kind of lift himself up and put the hands underneath? I don't know. You decide. Why did he have to say that? Because it's part of him wanting to be a cop. And that's what police officers do. Even when they shoot somebody, they usually handcuff them. Even if the person is dead, I mean, they handcuff them just for security purposes. The other interesting thing is, you recall the flashlight the defendant had in terms of in relation to where the body was. And again, the photograph that I showed you, State Exhibit 79, that was showing, I think, one or a few witnesses out there. And State Exhibit 80. Those are the two photographs that were showing out there that was taken, I think, by Officer Wagner. Defendant's gun. Do you recall what we heard about that from an expert regarding DNA? Swab from the pistol grip matches the defendant. And Trayvon Martin is excluded. That is inconsistent with what the defendant claimed to Mr. Osterman. Told the police he was going for the gun. He told Mr. Osterman that he had the gun or grabbed I think he described what part of the gun he grabbed. And then there's other test results, not limited, and then no determination made on the other side. In the holster. You had also, I will submit, relevant the fingernail scrapings of the victim in this case. What were the findings? No DNA foreign to Trayvon Martin, no DNA results at all. So the victim, in this struggle that the defendant claims he had with him when he was trying to kill him, basically, or shut him up so that he couldn't speak, where did all the blood go? Where did all the defendant's blood go? While we're on that subject, the defendant claims that he was the only one yelling out there. So all the cries for help were only him. You got to decide whether it was him or whether it was Trayvon Martin or whether it was both of them. It had to be one of them or both. But if he's yelling and if he's down and if he's got all this blood and he's swallowing the blood, how's he able to do all that? And why is there a consistent in terms of yells of help, 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 help. Why isn't it muffled down? Why is he able to yell if the defendant claims the victim was, how's he going to talk? Or is he lying about that? I would submit to you that's another lie. You saw that the hooded jacket was checked, and I'm just giving you very quickly the DNA results. You've got an exhibit there that's got them all in there. But just to demonstrate to you how thorough the investigation was in terms of the Florida Department of Law Enforcement doing their thorough analysis of the case in terms of the evidence. I remember we take it, I don't know how far we've gone.
If you're ready to take a break, we'll take a 15-minute recess. Ladies and gentlemen, please put your notepads face down on the chair and follow Deputy Jarvis back into the jury room.
I'm showing you a photograph of the left hand of Trayvon Martin. And obviously, in addition to the gunshot wound, that was the only other injury that was observed when the autopsy was performed. As you can see from that photograph, there is a very minute or small injury right there, and then an even smaller one over here, abrasion on his left hand. Recall also the testimony was that he was right-handed. Said, well, sometimes you hit something and you don't necessarily injure your hands. That's a possibility. Well, that could also be true for George Zimmerman's hands. The defendant, George Zimmerman, two people, one shot to death and one repeatedly lies about how it happened. Why might that be? You wonder? If one is shot to death and the other one lies, why would that person lie? He brought a gun to a struggle or to a fight that he started by following him and wanting to make sure that the victim didn't get away. And now he wants to let you to let him off because he killed the only eyewitness. The victim, Trayvon Martin, who was being followed by this man who had the right to defend himself. Defendant's interview, and you obviously know that he gave various interviews, and I want to just quickly highlight certain parts that I would submit to you are relevant as to establishing why this defendant is lying and why he was caught in numerous lies. And then obviously why it happened.
Wendy Dorval, Sergeant Hertz, Officer Buchanan, and I'm the coordinator. And there's been a few times where I've seen a suspicious person in the neighborhood. We call the police, the non-emergency line, and these guys always get away.
Okay. What made them suspicious? Any tape or recordings of vehicles that come in and out of that neighborhood?
The last time they were down, the cameras were
It has
broken.
the ability, but
Why did I put that thing about the camera there? Because as you recall, one of the ploys or tactics that was used by investigator Serena was to say, hey, maybe the victim had a recorder or maybe somebody videotaped it out there. He, the defendant, knew that didn't happen because he knew about it. He's the one that told the investigators, hey, contact Mr. Taylor or Leland, whatever his name was. I'll give you his number. It's on my cell phone. So he knew that there wasn't any videotaping out there of this. It wasn't like, oh, he took a gamble, and he was really defending himself, and so he said, hey, I'll volunteer. Go ahead and videotape it. Or I wish there was. No, he knew there wasn't any. So it wasn't like he was forthcoming with that information as like a truthful person.
go
Yes, ma'am.
Okay.
And dispatch asked me where he went. I didn't know the name of the street that I was on.
So you'd come off your street and go and do another street?
Yes, ma'am.
At some point, okay.
Goes in, cuts through the middle of my neighborhood.
Okay.
I didn't know the name of the street or where he went. So I got out of my car to look for the street sign and to see if I could see where he cut through so I could tell the police.
So after he circled your car, he disappeared again?
Yes, ma'am.
Okay.
2 key points there. Didn't know the street name. It's only 3 streets, and he'll tell you, you'll see it actually from his own mouth when he's talking to the investigators out there. He names the street. But no, most importantly also, or just as important, is the fact that he's saying this man, Trayvon Martin, is circling his car. So he's in such dire strait or so fear that he gets out of the car to go follow him. So he's either truthful in saying he's circling the car, or he's lying about it. Either way, it shows that he's not telling the truth. Because if he's really that in fear of, why does he get out of the car? Or is he saying that as another explanation as to why maybe he had to kind of confront him, as to explain that maybe, oh, it was the victim that attacked him. You see, the victim was already showing that he was going to do something because he started circling the car. And that's what a person that's about to commit a crime does. That's what he wanted the police to believe.
And find out where he went. And he said, we don't need you to do that. And I said, well, okay. He said, we already have a police officer en route. And I said, all right. And I had gone through the dog walk where I normally walk my dog, and walked back through to my street, the street that loops around. And he said, we already have a police officer on the way. So I said, okay.
However,
They said, would you like a police officer to meet you? And I said, yes. And I told him where my car was and the make and the model.
Mm-hmm.
So I was walking back through to where my car was, and he jumped out from the bushes, and he said, what the fuck's your problem, homie? And I got my cell phone out to call 911 this time. And I said, hey man, I don't have a problem. And he goes, no, now you have a problem. And he punched me in the nose. At that point, I felt dead.
Okay. So, few key things to remember there, or point out that I would suggest to you. Number one is where he walks his dog, but he doesn't know the name of the street. In terms of getting there, there's only, again, 3 streets. Number two is he's walking back, even he's told not to follow him, so he decides to obey, even though he wasn't ordered not to follow him, but he decides to go back to the car. When this man came out of the bushes, you will see that he changes that, and he catches himself. But you'll see it's coming up, because number one is to where those bushes were, but he also, at some point, catches himself when he says, I was going towards him. Oh, he came towards me.
Didn't even see him getting ready to punch me. As soon as he punched me, I fell backwards into the grass.
This man, Trayvon Martin, this teenager, came at him. Now, he's out there in the darkness, and he's got a gun, but of course, he hasn't taken his gun out, because that would be illegal. He's got the right to conceal it, because he suspects somebody of a crime. He's not a police officer. He can't go arrest him. But he's just kind of wandering out there in the darkness, even though this guy has circled his car, but he's not in fear. He's just kind of wandering. Does that make sense? He goes out to the darkness after somebody he's scared of, and he's not on guard to what's going on. See, because he's got to convince the police, and by virtue of giving that statement to the police, convince you, the defense has got to convince you, that he was just kind of walking and the victim came out of nowhere.
Object, Your Honor. Let me approach for a moment.
just tell me your legal objection.
Improper presentation of the case law and the law concerning my client's obligations to prove anything.
Okay, ladies and gentlemen, at the close of the end of the attorney's closing arguments, I will instruct you on the law that's applicable to this case, and you will be given that law back to the jury room to compare with how you find the facts to be. Thank you. Go ahead.
He's trying to convince the police that he hadn't done anything wrong.
And on my nose and on my mouth. And he says, "You're going to die tonight." And
Again, now he's saying that the level of violence towards him is escalating. Because Trayvon Martin just decides to shut him up by, and the amazing thing, and I'm going to get to this in one of the slides that you will see, or the PowerPoint presentations you'll see, he must have had like 10 hands out there, or 10 arms, because he's able to do all this while the defendant's just sitting there, letting him put his hands over him, not doing anything. Does that make sense?
my jacket and my shirt came up. And when he said, "You're going to die tonight," I felt his hand go down on my side, and I thought he was going for my firearm. So I grabbed it immediately, and as he banged my head again, I just pulled out my firearm and shot him.
Okay. And then what happened? Did he...
So the gun wasn't exposed earlier. He's getting beat up, but he hasn't taken the gun out. It's only when the victim starts reaching for the gun. Now, he tells Osterman that he actually grabbed the gun or touched it. But he says he's reaching for the gun, and then I realize as he's holding my hand, one hand over my mouth, one hand over my nostril, I can't breathe, but I see it. He's got that third hand that he's going for the gun. Does that make sense? And the victim only went for the gun because the gun became exposed. Your Honor, with the court's permission, I've had the deputy check it. The gun, I'll have to check it again. Thank you, sir. He's got this gun in his holster. And you'll see in a few minutes, maybe more than a few minutes, one of the things that he does, he demonstrates to the police where he had the gun. And it wasn't right here in the front, it was towards the back and it was hidden. And he'll demonstrate to the police out there where it was. Look at the gun. Look at the size of this gun. How did the victim see that in the darkness? Where was it? It wasn't outside, it was tucked in behind. And he'll demonstrate to the police where it was. How did the victim see this gun? Or is it just another lie that he tells?
So I remember once I shot him, I holstered my firearm and I got on top of him and I held his hands on because he was still talking. And I said, "Stay down, don't move." And then
A key point in that is that he tells the officers out there, the police station and later out at the scene, that he didn't realize originally that he had shot the victim. Well, if he's in such fear and he doesn't realize he shot him, what the heck is he doing holstering his gun? If he's so scared. Or is that just police jargon? That's what police do when they shoot somebody. First they make sure the person's either dead or handcuffed, and then they automatically holster the gun. But he's got that police jargon talking, and that's what the police are taught. But if he's so scared, what is he doing holstering his gun? Because he claims at one point that the victim said, "Oh, you got me," or something, and he thought, oh, he scared him. Because he's trying to convince the police that he really didn't intend to shoot him at that point. That, yeah, he was in fear, but he really wasn't intending to shoot him. He was just trying to kind of scare him, maybe.
recall, it's always dark. They always come around nighttime. And
They always come around at nighttime. They being, pardon my language, the assholes or the fucking punks that are committing these burglaries. Again, going back to that assumption that he made originally when he profiled a 17-year-old boy that had Skittles. That's the crime he committed that evening. Skittles that he didn't even steal from 7-Eleven. He legitimately bought. You saw the videotape. He wasn't instilling fear into that clerk over there because he was wearing a hoodie. But somehow, this man right here became suspicious of a 17-year-old kid who's wearing a hoodie at 7 in the evening or 7:10 in the evening.
Straight through to see if there was a street sign that I could tell dispatch where I lost sight of him at. And when I walked back, that's when he came out of the darkness, and I guess he was upset that I called the police.
Now he's starting to speculate or trying to convince the police, oh, I guess that's why he must have attacked me or why he came out, because he must have been upset that I called the police. See, he's trying to justify to the police why he did what he did. And of course, it's not that he came to the wrong assumption originally. It's no, I was just checking for the street sign. I was just doing my job as a neighborhood watchman or just a citizen concerned about crime. And I guess he came out of there because he must have realized that I called the police, meaning that first assumption still existing in his mind. He is a criminal, and that's what criminals do. They don't want to get caught.
Cell phone away.
Okay.
And then when I walked back towards him, I saw him coming at me.
Did you hear that? When I walked back towards him, he switches mid-sentence. I saw him coming towards me. He acknowledges at that point that he is the aggressor. He's the one that's going and pursuing the victim. But he catches himself when he says that, and then he goes, oh, he walked towards me.
And I went to grab my phone. I don't remember if I had time to pull it out or not.
And he claims that he went for the phone. See, because he's got to then explain why he, being a 5'7", 204-pound, perfectly healthy 28-year-old man, is overpowered by this 5'11", 158-pound kid. And he, being the one that's tracking him or following him, he's on guard. He's got 2 flashlights. He's got a gun. This kid is the one that's scared because this guy's following him. He's got to explain why this kid got the upper hand. Oh, I was going for my phone, and I just got distracted. Was he going for his phone, or was he going for a gun? Were they in the same place? Defendant's interview that same day, part 2. What did he do there? He drew different areas, and it tracks in terms of where he was, where he claims he saw the victim, where the victim just came out of nowhere, where the victim was just kind of looking suspicious. And you know, you've got that in evidence, so I'm not going to spend a lot of time with that, but he drew the different places where he claims the victim was and what, in his mind, caused him to be suspicious of a 17-year-old boy. Defendant's photographs taken of the defendant that you saw. Defense made a big deal. Oh, he was washed up. Well, you've got this bloody photograph here, and you've got that. I guess, and according to Dr. DeMayo, I guess one of the EMS people out there just kind of put it back in place. Put the nose back in place because you heard from Ms. Fallgate. She didn't see anything. She saw it might be fractured. They don't know. What she recommended is go get x-rays. That's how we verify it. Defendant refused or declined to do that. That's his privilege. But they're going to argue to you, oh, he had a broken nose. Well, first of all, who was following who? Who started the fight or struggle? I circled this because in reviewing the evidence, I thought this might be interesting to you. And what I'm circled up there are his shoes. The defendant told the police that he was on his back the whole time and the victim was just wailing on him. Well, and you can look at the actual photograph, there's actually some grass on top and it appears wet, as if maybe he at some point was on top of the victim. Just a minor point, kind of corroborates some of the evidence, the witness's testimony. Says Exhibit 52, the back jacket of the defendant. Wow. Where's all the scrapes, scratch marks, something to reflect all this tension with these concrete that occurred out there? How come it's missing? Back of his head. You recall the testimony? There was two. How small were they? You recall the testimony of the witness, Miss Folgate? I think I had her. Tell me how big it was. And I think she was, it was hard to keep. Anyway, you remember it. Why are his hands not injured? If this 17-year-old young man is wailing on him, how come he's not defending himself? And again, these are just little parts of the interview that he gave, and you obviously heard this, so I just want to take you to take a second to read that. But he talks about these guys, he talks about not knowing the places. Again, he's trying to make up one lie after another after another. Yeah, he was serving in my car. As soon as I saw him coming, I rolled up the window because I was so scared of him. Because he was a criminal. I didn't know the name of the street that I was on. And then he talks about, they remind him, we didn't need you to do that. Had already gone through the dog walk, told him where my car was, make and model, jumped out of the bushes, hey man, you have a problem, and then punched me and fell to the ground. And then he's wailing on my head. And I yelled for help. He grabbed my head and hit it into the sidewalk. When he started doing that, I slid into the grass, still yelling for help. Help, he's killing me. And then, of course, this criminal put his hands over my mouth and said, you're going to die tonight. And that's what, of course, led me to the gun. He's got that legal training that he's aware of in terms of what he's got to say. He, the victim, said, you got me after being shot. And he was still talking. I said, stay down, don't move. I got on top of him. He said, ow, ow. And then he talking about that he's telling the people that came out, I don't need you to call the police, I need you to help me with this guy. But he holsters his gun too at the same time. It's always dark. They always come out around nighttime. is of such a nature that the act itself indicates an indifference to human life. And in order to convict of second-degree murder, it's not necessary for the state to prove the defendant had an intent. It's not first-degree murder. We're not saying that he intended to go and kill him. Read those for a moment there. They speak volumes of his choices. Isn't that the truth? Isn't that the truth? Victim really didn't get to choose anything, did he? Or anyone? State is, the instructions that the court will read to you will tell you in part that the state has charged this defendant with second-degree murder. If you return a verdict of guilty, it should be for the highest offense which has been proven, and there's a lesser included. And Hurricane Katrina wasn't just a thunder shower. In other words, your duty is, if you find him guilty beyond a reasonable doubt of the highest crime, then if not, then you go to a lesser crime. Manslaughter, you commit an intentional act which resulted in the death and use a deadly weapon, excusable or justifiable. You'll get those instructions too about no action or misfortune, etc. And the court's going to read the whole instruction to you. I just was. In terms of how you decide, and we talked briefly about that, it's to the evidence introduced into it alone. Case must be decided only upon the evidence and the instructions. What the lawyers say is not evidence, and you are not even to consider it as such. You may not decide because you're biased or sympathy or angry at anyone or feel sorry for anyone. Why do we have such rules? What if? That's not a lack of evidence. There could always be more. That's not reasonable. You will not hear, because a lawyer or Hollywood screenwriter can imagine something more than could be done, you must find the evidence lacking. You know, we don't have a big animation of how it happened. Did anybody see it out there? The defendant told the police this is what happened. There were no eyewitnesses to the actual shooting. Doubt? And again, what's not reasonable? Self-defense. This is what the defendant applied to Virginia. Hunt down fugitives, and you'll see the letters, emails, etc. Isn't that true? Again, the key point is that injuries really are not required if a person is legitimately in fear for their life. But why exaggerate them? Unless he's lying about the whole thing. Yeah, no DNA. Fingerprints also weren't on the gun. Blood wasn't there. Credibility. But Should you believe the defendant? Think about this. What a coincidence. Does that make sense? Think of the jacket as he's claiming he's going down an angle. Which way would it go? Would the gun be exposed, or just the opposite? Think about this. Doesn't that speak the truth? What a coincidence. The shot, all of a sudden the yelling stops. You see where some of those injuries are? What, did they pick up a sidewalk, or did he turn them upside down? Or is it just by scraping and rolling and fighting out there? They both were. I'm wrapping this up, believe it or not, and I thank you for your time and your patience. I ask you to come back with a verdict that speaks the truth, a verdict that is just. You heard from many people in this case, and I've summarized some of them. There's a lot more actually that you heard. We know you paid close attention throughout all these proceedings. Some of the people you heard from were the parents of both the victim and the defendant. Unfortunately, the only photographs left of Trayvon Martin are those ME photographs. I mean, they've still got other photographs, and you saw some of them, the football when he was younger days, but they can't take any more photos. And that's true because of the actions of one person. The man before you, the defendant, George Zimmerman. The man who is guilty of second-degree murder. Thank you.
Thank you. Ladies and gentlemen, we're going to recess for the evening. Before I let you go, and while you're getting your notepads to be ready to put face down, I'm going to give you my instructions. You're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any emails, text messages, or social networking pages about the case. You're not to create or read any of those. You're not to get on the internet to do any independent research about the case, people, places, things, or events, and you're not to read or listen to any newspaper, radio, or television reports. Do I have your assurances that you will abide by these instructions? Okay. We will be in recess until 9 a.m. Please put your notepads face down and follow Deputy Jarvis back into the jury room. Please be seated. Counsel, you've got the final draft of the jury instructions in the verdict form. If you'll let me know in the morning if there's any issues with them.
I'd like to point out just Mr. Zimmerman's name is misspelled on the verdict form.
On the verdict form?
Yes. His name is spelled on the verdict form ZLMMERMA.
The one I have, it has Z-I-M-M. Right, it's the same as it is on the jury instructions.
Well, mine isn't. I thought I had the right one.
It's not it's the first sentence, not the
Not the
style.
style.
Oh, I see. I thought you said the style. Yes,
No,
if
no.
you'll correct that on the first sentence.
It's
First,
two, right?
second, and third, all of them.
Yeah, all of them.
You put a capital I instead of a small I in all those. So the second page seems to be fine. It's the first page. And if you'll let me know if there are any other concerns or issues regarding the jury instructions. Is there anything else that we need to take up before we recess for the evening?
You're going to bring those other items in the morning? Thank you.
Okay, the other item?
Anything from the state?
No, I apologize, no, Your Honor.
That's okay, thank you, good night. Court is in recess until 8:30. Have you resolved Defense Exhibit 39? Mr. DeLu?
Yes.
Okay, so 39 is,
I apologize.
Is marked as 39, and needs to be accepted by the court.
it'll be accepted by the court. Thank you, Sarah.